Mr. Driscoll.
Thank you, Your Honor. May it please the Court, opposing counsel. Your Honor, my name's Kevin Driscoll, and I, along with Kellen Bubach, are here representing Larry Stoller in connection with our appeal. We're here today asking this Court to reverse the ruling of the Grievance Commission that found that Mr. Stoller had violated the Iowa Rules of Professional Conduct in connection with his representation on two separate matters, those being the Okoboji cocktail matter and the New Star versus Zylstra matter. And with the Court's indulgence, I will address the New Star Zylstra matter first. In that case, the Commission found that Mr. Stoller had violated three rules of professional conduct: the rule against concurrent conflicts of interest under 32.1.7A2, the rule against not obtaining informed consent, 32.1.7B4, and the rule against representing a party against a former client in a matter that was substantially related to that former representation under 32.1.9A. We submit that based on the record before the Commission, there was not sufficient evidence to support a finding by a convincing preponderance that there was any concurrent conflict of interest under 32.1.7A2B, 32.1.7A2, because there was no evidence at all that there was a significant risk that Mr. Stoller's representation of New Star would be materially limited by his former representation of Mr. Zylstra, and therefore no violation of that rule occurred.
The problem I have with that argument is he did send a bill to Mr. Zylstra for reviewing the manure agreements. Then he's on the other side of the controversy subsequently relating to those agreements. And then his defense is, well, I wasn't really advising him on the manure agreements. I was telling him to go get another lawyer, which seems to be supported by the record. But I put in the bill that I was advising him on manure agreements because Mr. Zylstra wanted that so he could deduct the fees. It seems to me the more he says, the digger he's digging himself a little bit here.
Well, and I want to dig into the manure easements because I think that goes to the violation of that's been alleged under 32.1.9A. The letter on January 24th, 2007 that Mr. Zylstra sent, that Mr. Stoller sent to Mr. Zylstra is a declination letter, in my opinion. And if we look at what he stated in that letter, he clearly said, you asked me to look at these manure easements today. I briefly looked at them. I don't know much about them, and I suggest you go have them reviewed by Dan Decoder, an attorney representing you in connection with the sale of the Sibley Dairy. Mr. Stoller did not undertake representation of Mr. Zylstra with respect to these manure easements.
If he didn't, why did he charge him?
Well, he charged him for a bill related to estate planning, characterized inappropriately as related to the manure easements. And that was at a request of a client that he obliged that request. But if we look at those manure easements that were recorded as a matter of record, look at its exhibits A1 through A4. And I think that if you look at those easements, A1 and A3 are for the same parcel of land. A1 is a 10-year term, A3 is a 15-year term, and it's the same thing with A2 and A4. Manure easements with inconsistent lengths of term were filed as a matter of record, and Mr. Stoller didn't represent Mr. Zylstra. He didn't negotiate them, he didn't draft them, he didn't revise them, he didn't record them, and he certainly didn't represent Mr. Zylstra in connection with the sale of the dairy. So when you look at the manure easements and you compare it to A5, which is what Mr. Zylstra characterized as the critical manure easement, because that has the terms and conditions relating to the amount of manure that would be spread, the cost associated with that manure application. If we look at A5, Mr. Stoller never saw that easement until his client, New Star, brought it to him, and it was signed. And in the examination of Mr. Zylstra at the commission hearing level, He couldn't testify that he ever submitted that to Mr. Stoller because the only version Mr. Stoller had was a signed version that was provided to him after the fact. So I think if you look at the evidence, the commission did not prove by a convincing preponderance that Mr. Stoller had in fact represented Mr. Zylstra in a substantially related matter. And therefore, there's not a violation of 32.1.9. And if we look at...
That may be true when you talk about the A9 violation, but when you talk about the 7 violation with the concurrent representation, it was clear that during the time that he was looking at these manure easement agreements, that he was in fact advising him and counseling on these agreements. We have the bill, of course, from that conference with him, and then we also have his office notes that are part of the record as well, setting forth kind of an outline of things that need to be discussed with possible counsel. You know, that his advice and counsel as to what you ought to do with these agreements and talk to another lawyer, but that doesn't relieve you of the representation of him at that time.
It's our position, Your Honor, that he did not undertake representation. And Exhibit 20, which are the notes of the conversation, those are consistent with Exhibit 19. Refer Robert to DeCoster for I can't make out it, but for review. He said, I don't know about these. I can't help you. Go to another lawyer. That doesn't mean that he's engaged with respect to those manure easements.
Can't you do both, though? I understand what the exhibit says, but a lawyer who's not an expert in manure agreements can still review them and do some issue spotting and raise some concerns about them, and then add on saying, you know, I'm not very much an expert. You really should get outside counsel. But I'm not sure that they're mutually exclusive. Help me with that.
Well, our position is, Your Honor, is that he did not provide advice or counsel with respect to the material terms of these agreements. He wrote some notes that were questions that Mr. Zylstra had, and it's on Exhibit 18. He wrote some notes of the questions with respect to why the time, why 36 months versus before you could call the deal off, and should you have the method of application. What happened then is Mr. Stoller said, go to somebody else and get that revised, and that's what Mr. Zylstra did, because the manure agreement that Zylstra presented Stoller on January 24th is different than the ones that got recorded. Somebody revised those agreements, and it wasn't Mr. Stoller. He didn't undertake representation. He didn't provide advice. And I think the critical issue for this court here is that Judge Courtney heard this matter on an evidentiary hearing, and Judge Courtney's ruling is the standard for this court, I understand, is an abuse of discretion. Judge Courtney did not abuse his discretion in the manner in which he concluded that Mr. Stoller had not undertaken representation and should not be disqualified. Judge Courtney indicated that courts must be vigilant to prevent a motion for disqualification from being wielded as a weapon for harassment.
But wouldn't you agree, in his order, he's really looking at the subparagraph 9. He's really looking at and applying the standards that we utilize in analyzing whether there's a conflict for a former client as opposed to perhaps a concurrent conflict of interest, which is another basis under which he could have ruled but did not in this case.
That's a fair assessment, Your Honor, but the fact of the matter is that he found that there was no former representation that was substantially related that required Mr. Stoller to be disqualified.
And that's the qualifying language, that he doesn't say that there wasn't any former representation. He just says that there's no former representation that's substantially related to the issues here, which is different than saying that there's no former representation and getting around the other aspect of a conflict of interest, a concurrent conflict.
Right, but I think the other fact of the matter is that at the time of the hearing in New Star, there was no representation of Mr. Zylstra, and so there was not a concurrent conflict at that time to disqualify Mr. Stoller. And I submit to you that Judge Courtney got that right, Your Honor, and the Commission got it wrong when they said that there was a substantial relationship. And I think that that's a concern that this court should protect a litigant's right to choose counsel and not permit opposing party to use a motion to disqualify to preclude their right. I also want to comment on the fact that in connection with the Zylstra findings by the commission, they entered a sanction restricting Mr. Stoller's use of a handgun. And we've briefed that before the court. That was nothing that Mr. Stoller had notice of. We certainly would have provided greater evidence at the hearing had we known that there was a possibility that his use of a handgun could be restricted. The record shows Mr. Stoller keeps an unloaded gun in his desk for protection because he's had incidents in his office on 2 prior occasions. The characterization that was presented to the commission by Mr. Zylstra was greatly exaggerated, and there was not a waving of a handgun in a courtroom, certainly. Mr. Stoller keeps that gun for protection, as I stated, but the board wants to use the fact that he had a previous domestic abuse charge as a basis for precluding his right to have a handgun. And we've briefed this issue that there was a deferred judgment that has been expunged from Mr. Stoller's record. Iowa Statute 9073 and 9079 allow for the expungement. That conviction, it was not a conviction, it was a plea bargain. That has been expunged from his record, and under the federal statute, 18 U.S.C. 1992, there is no conviction because an expungement under 18 U.S.C. 1921 precludes the finding of a conviction. So there's no basis in law to preclude Mr. Stoller from having a handgun. I'm going to turn now to the Okoboji cocktail matter, Your Honor. Your Honors, that matter, there were 2 violations, one on the concurrent representation of two clients, the Martins and the Chaplins. My time is running quickly here, and I just want to address the Okoboji matter in its totality. And I think that's what this court needs to do too. Mr. Stoller was faced with 2 clients who were dealing with a bad situation where Okoboji Cocktails had lost its corporate status, they'd gone out of business, they'd abandoned the property, they left the premises unsecured and unlocked with rotting food, with past due rent. Ms. Chaplin had a $14,000 tax lien levied against her own personal bank account because of the actions of Mr. Dahl and others. Mr. Stoller certainly exercised self-help in that matter. Was it a good idea to seize the property of the tenant and transfer it to the to the landlord? No, it wasn't. Was it malpractice? Yes, and I represented Mr. Stoller in that matter, and we had a long talk about that. But the fact of the matter is there was not fraud and deceit and dishonesty in connection with those transactions. I'd refer the court to the Oderkirk matter that also involved transferring of property by use of various agreements that don't rise to the level of fraud and deceit. Mr. Stoller got a fair market appraisal of this equipment. While the other side disagreed with his appraisal, I don't think the market of used restaurant equipment is such that one party can say definitively that a $6,000 appraisal was that far out of line. Mr. Stoller was able to get $6,000 from Mr. Martin to Okoboji Cocktails in connection with the landlord retention and transfer of that property. Judge Carr did characterize it as a sham transaction, but I don't think that rises to the level of fraudulent intent. I'd also submit that a 90-day suspension is excessive in light of this court's rulings in Marks and Mendez, where they held for a lesser extension. I'd ask the court to consider that Mr. Stoller is a solo practitioner. A 90-day suspension would cause a great hardship not only on Mr. Stoller's staff, but on his clients, who are going to be forced to find other counsel to represent them. I'd submit to you that a public reprimand is sufficient. And in fact, a public reprimand was offered to Mr. Stoller initially. Little did he know that it was a take it or leave it offer, and when he asked if he could have a private admonition, the offer was withdrawn and the charges were filed. But I think the court should take into account the mitigating factors of Mr. Stoller's work as a mental health advocate and his long-serving work as an attorney in Northwest Iowa in respect to any sanctions that should be applied in this matter. Thank you, Your Honor.
Thank you as well, Mr. Driscoll. Mr. O'Brien.
May it please the court, counsel. Seems fundamental you shouldn't be suing your own clients, and that's exactly what Mr. Stoller did here. It isn't like Bob Zylstra had never seen Mr. Stoller. Mr. Stoller had been representing him for 10 years or more.
But you can sue your own clients if they're not your current clients and if the matter's not substantially related, isn't that right?
That's right. But in this case, on the one hand, Mr. Stoller is representing Zylstra in a small claims matter. He's a concurrent client. He's writing him in May saying, well, I don't like you anymore, and therefore you're a bigot and a zealot. And on the other hand, a month later in June, he says, oh, the small claims ruling has just come down, and I'll represent you, provided you give me $525 retainer and $50 filing fee, and oh, by the way, you owe me some fees. So I think you have both here. So that's what was going on, at least in the Zylstra matter. Zylstra thought there was certainly a conflict. He thought the matters were related. He had gone to Mr. Stoller, asking him about this manure agreement that someone else had drafted, wanted to make sure it was okay. Mr. Stoller gave him an opinion. Actually, there's writing, Mr. Stoller's writing on these manure agreements. Revisions were made consistent with those writings. One of the panel members brought that out in the hearing.
But counsel, by that time, Mr. Zylstra, the Zylstras were represented by other counsel, weren't they?
True. That's true. Mr. Sandy had stepped in, and Mr. Sandy had even written, as did Mr. Cease, saying, wait a minute, you have a conflict here. You need to withdraw. And that's the other matter before you that will be heard non-orally. The board isn't taking a position in that case. The evidence was a little different. Exhibit 33 is the actual ruling on page 7. I think perhaps Judge Courtney looked at only the affidavits and didn't look at the rest of the record. I'm not sure how he came to the conclusion that...
You make a statement that the record's different. It didn't strike me that the records were different, really.
Well, we had more evidence, and there was considerably more testimony from Mr. Zylstra. He went on and on and on about what that meeting was about. It wasn't about estate planning. It was about the manure agreements and whether or not, because they had adjacent farms. And the Zylstras owned, they were partners in a limited liability company that was selling over this dairy to the Nustra, the Nunes family. So we're dealing with two farmers here, essentially, that are neighbors, and then they had all these side deals.
I mean, recollections of both parties can be faulty or as time passes, but we do have this letter that Mr. Stoller sent right after the fact, and it says, as I told you, I don't know much about these types of easements and suggest you have them reviewed by Dan Dakota, as he's the attorney representing your group in the sale. The changes you were talking about should be run by them, and I suggest that if approved, they be included in the easements. I would also think that some permit would be necessary, but Dan or Don will know. I mean, that doesn't sound like if there was advice, it was very substantial, does it?
Sounds to me like you're asking for a third opinion. You're getting a second opinion on something you don't really know a whole lot about, because, this is your family lawyer. You come to this person and show them some manure agreements and say, hey, what do you think? You look at them, there were some notations made. Well, I think this, I think that, I think this, but, oh, by the way, I'm not really an expert in this. You should go see someone else.
But is that substantial? I mean, if I understand it correctly, the prior representation has to be substantial, and the mere suggestion of a couple issues, but then you better get somebody who knows about these things. Is that really a substantial representation?
I think under the facts of this case it was, because this is all interrelated. Manure agreements were, from Zylstra's standpoint, he's going to see his lawyer, and then 7 years later he gets sued over the same things that he'd been in there talking with him about. And so Mr. Zylstra files his bar complaint. and here we are.
Something bothers me about this substantial thing, and it's on page, it must be 23 of the appendix, but the board says, and they cite a 1999 case to reach their conclusion that there was a conflict. The board says, for a law firm to represent one client today and the client's adversary tomorrow in a closely related matter creates an unsavory appearance of conflict of interest that is difficult to dispel in the eyes of the lay public or even the bench of the law. And I think back in 1999, that was probably a proper standard. But when the rules were rewritten in 2005, the ABA took out as a, I see you're shaking your head so you know where I'm going. The ABA took out of the Code of Professional Conduct being disciplined for just the appearance of impropriety. And I think the substantial, is something that avoids the appearance of impropriety thing. And it seems like the board based their finding on an appearance of impropriety rather than an actual conflict. And that's what's bothering me about this Zeistra stream, that we're applying old law and old standards to a situation that happened after 2005.
I think you're talking about the Bottoms case where this court went that direction, but then in the Bottoms case itself, there was a proviso in there, or if I'm remembering it correctly, based on the record we have now. That's not to say that there won't be a
This was the
showing.
Walters case they said.
Right, the Waters case, and that's Justice Snell's opinion under the old disciplinary rules. But there's more than an appearance of impropriety here. We're talking about stuff that's very close related. I mean, it's not like we've got a bankruptcy and an auto accident. I mean, we're talking about the sale of a farm with manure agreements, which was part of the deal.
But, I come back to what all my fellow justices said. Was he really representing him or telling him, I really can't represent you because I don't know anything about it? At a distinction that doesn't
Well,
matter.
why did he send him a bill for $130 for 1.2 hours? And called it review of manure agreements. I mean,
Maybe he had to look it up and figure out he didn't know anything about it.
exactly.
Usually take me more than an hour to figure out I didn't know anything about something.
But it wasn't free curbside advice where you just, comes in, well, hey, I don't know anything about it here. Let's, I'll bill you for something else. But that isn't what happened here.
Tell me one other thing, and counsel brought it up, and I didn't see it in the record. Is there anything in the record about a public reprimand versus not taking it, or is that wholly outside the record?
I think it's wholly outside the record. I'm not allowed to talk about that sort of thing. It's my understanding.
Your position is we shouldn't consider any of that because it is outside the record.
That would be my position. I'd be glad to elaborate if the court wants me to, but I don't think I'm allowed to do that.
Well, with respect to sanctions, what about the recommendation concerning the provision regarding the firearm? Can we impose such a condition without any notice?
That's a very good question. I don't know the answer. Seems like a good idea. I think this court can do whatever it wants in terms of making sure that sort of thing doesn't happen. I think I was as surprised by it as anyone. We had not advocated that.
Wouldn't we be depriving him of an opportunity to make a record on it if we were to do it without any notice?
I would think so. I think that's been consistent with what this court has done in the past. But, there's that federal code section, and I'm not so sure that under the federal rules, because I have not researched it, whether or not a deferred judgment still allows you to keep a firearm. I think they weren't trying to keep him from having a firearm. The recommendation was, well, if you have one, let's put it in a locked safe somewhere and don't be waving it around in front of your clients.
But under Ruffalo, the U.S. Supreme Court case, I don't even know how we could even address that issue without violating his due process rights. And Ruffalo's pretty clear about that. You can't
Right.
change the ball in the middle of a disciplinary hearing.
And I would agree. I would agree with that.
Where does the board stand on sanctions?
Well, clearly there should be a suspension. The only issue is how much. I mean, you have a long pattern in 2 cases here was some pretty egregious conduct, and we would defer to this court. I mean, sanctions have ranged anywhere from 30 days to 6 months or longer for this sort of thing, where you have multiple violations of the code. We would submit that, you know, there were a number of matters that we alleged that were not found. We would ask this court to exercise this de novo review, especially on the business about whether or not he impermissibly contacted a party opponent. That's how this whole matter began.
Shouldn't we defer to the commission's fact-finding on that if that's a credibility issue?
You can defer, you don't have to defer, as you well know. I mean, the Zener case that you just cited a month or so ago, or someone did, and that Committee versus Doe case, this court is free to consider everything, including matters that the grievance commission did not find.
Counsel, I want to focus on the claimed violation of 32(1.7A2, which, as I understand it, involves the allegation that that Mr. Stoller concurrently represented New Star and the Zylstras in 2014, when there was the pending small claim matter, and we were leading up to the other litigation.
Correct.
And so what I'm wanting you to focus on is what was the significant risk that the representation of Zylstra in the small claim action posed a significant risk that Stoller's representation would be materially limited by his responsibilities to the other client in that 2014 timeframe.
It goes back to the fundamental principle of loyalty to your clients, and whether or not you should be suing them on the one hand when you're defending them on the other. The client feels that they're not being fully represented because their lawyer has mixed and divided loyalties. It's that simple.
Even though the matters were totally unrelated, you think the loyalty problem is enough?
The comments to the rule seem to suggest that. Comment 7 to that rule seems to say that. It's a perception that the lay people have. Here I'm being sued by my own lawyer, for crying out loud. And for that reason, in the comments, it doesn't seem permissible. I mean, as an attorney, if you're being advised that, hey, I have a conflict, get out of the case.
On the Okoboji cocktail matter, was there, in evaluating a sanction, was there harm to a client or to a third party?
There's certainly harm to the third party. They had their items seized. They spent tens of thousands of dollars on Attorney Cannon to try and get them back. He cut his fee in about half.
I have to hire a lawyer anyhow. I mean, it sounds like, big picture on this Okoboji cocktails matter. You had the tenant of this bar had kind of, they had disappeared. They left Iowa, as I understand it, and the company had been administratively dissolved. They weren't paying rent. And it strikes me, commercial lease context, the landlord was within its rights in doing the lockout, but needed to go judicially if it wanted to enforce the lien on the property that was left on the premises. And so what we're really talking about is too aggressive an approach in seizing that property and then having it turned over to the other client of Mr. Stoller. I think her name was Chaplin. Is that basically right?
That's basically right. I mean, you had a concoction that Mr. Stoller created about, he incorporates her, he has her sign away everything. She's only a registered agent. When you had, as Judge Carr pointed out, what should have been a relatively simple matter over a couple $1,000s rent lasted a year, year and a half in protracted litigation. It finally got settled only after Mr. Stoller was removed. I see I'm out of time. Thank you.
Mr. O'Brien, thank you as well. Mr. Driscoll.
Under the board's interpretation of the professional rules of ethics, they would never allow an attorney to sue a former client if the standard that they're going to impose is held here. I think the important distinction is that they had the burden of proof to establish by a convincing preponderance that there was that the matters that Mr. Stoller represented Zylstra on previously were substantially related to the New Star case.
How do you answer his concurrent representation argument?
There was no concurrent representation, and in fact, the board didn't allege and the commission didn't find a violation of concurrent representation. Stoller wasn't representing Zylstra when he filed the New Star lawsuit July 9th of 2014. The small claim...
What about the correspondence, the emails prior to that?
Well, the small claims action was tried in February, got a decision in May. He wrote the letter of terminating his relationship May 13th, and then the appeal comes in and he sends it to him and he says, if you want to hire me, let me know, but you're already represented by other counsel. No retention was made with respect to the appeal on the small claims action, and the deadline for filing the small claims appeal expired June 19th, I think. So he was clear. He's out of the woods in terms of any concurrent representation.
Well, wasn't there a period of concurrent representation, though, of both New Star and the pending small claims matter, at least up till mid-May of 2014?
I say that once he sent that May 13th letter, Mr. Zylstra testified, I understood he's no longer representing me. But the concurrent representation between the small claims action and the New Star matter really hadn't, developed. The New Star matter was simply a matter of requesting the deed.
He hadn't withdrawn from the small claims matter. He hadn't sent a letter saying, I'm out of it, and it was still technically pending, right?
Yes, he did not withdraw. He terminated representation, but he didn't file a withdrawal in the small claims action.
But under our rules, you're not terminated or you're not representing somebody unless you withdraw from the proceeding.
I mean, that's a fair assessment, but I think when you look in the context of what was going on, the small claims action had nothing to do with New Star.
And I agree with the assessment that it's not alleged, so
right.
That raises a different
it wasn't
matter.
Alleged, nor was there a finding of that.
Well, I think that's incorrect. I think there's a finding of both. There is a finding of concurrent conflict of interest in the New Star.
But not under 37(1.7)(a)(1). It was under A2, Your Honor, and I believe that's the distinction. The other fact is that going back to the consultation on the manure easements, he also did talk estate planning with him. He provided him with a checklist for estate planning and again referred him to other counsel. So it's not as though he was representing him on the manure easements or the sale of the dairy. And for them to characterize Mr. Stoller's representation on the sale of the farm and the manure agreements is not borne out by the record in this case. As far as the Okoboji cocktail matter, Mr. Dahl was in jail. He was unreachable. Mr. Stoller tried to write him, sent a letter March 1st advising him of the landlord lien. There was no response to that. With respect to Ms. Schmidtke, the commission found that she was not credible and that Mr. Stoller was simply attempting to obtain the tax or get the tax records back so they could file the taxes and get this $14,000 lien off of Ms. Chaplin. And it's the board's burden to prove that there was an improper contact, and the commission found there was not. And so in that respect, this court, I believe, should defer to the commission on that. Again, we ask that the court reverse the commission's finding on the Zylstra matter and at most impose a public reprimand for the Okoboji cocktail matter. And we believe there was reference in the record with respect to the offer of a public reprimand. I believe it's in Mr. Stoller's letter that he wrote in response to the original claim that was filed against him, but I would need to check that and could provide that to the court if you so desire. So, thank you, Your Honors.
Thank you as well, Mr. Driscoll. The case then is now submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.